The next bill on the agenda is House File 15. It's a Representative Frazier bill. Representative Frazier, would you like to move your bill to be re-referred to the Committee on Judiciary, Finance, and Civil Law?
Yes, Madam Chair, that is my motion.
All right, Representative Frazier has the bill before us. We also have the A5 Authors Amendment. Would you like to move the A5 amendment?
Yes, Madam Chair.
All right, so moved. And if you can briefly explain the amendment, we are really running short on time here. I will also just note for members, just like with the last bill, there's a DE amendment in your packet. We won't be discussing that. That's just so that you can follow along with what the A5 amendment does. To the amendment, Representative Frazier.
Madam Chair, I don't know how quickly Jeff could do this, but I can forego my opening statements and let Jeff get directly to explaining the amendment, and I can kind of, sprinkle in my statements as we're having discussion.
Very well.
How about that?
Thank you. Mr. Debo.
Madam Chair and members, the A5 amendment to House File 15, first few lines through 1.4, authorizes petitioners to file in their home of residence or where the office of the official is located, not just where the the respondent is located. The page 1, line 5 clarifies that an order under this proposal would prohibit someone from possessing or purchasing a firearm. 1.6 makes a clarification to provide flexibility for extensions of the order. 1.7 to 1.8 provides clarifying language as to which officials are entitled or authorized to file a petition under the statute. 1.9 through 1.12 of the amendments clarifies that an extreme risk protection order is not limited to jurisdiction in Minnesota. It applies nationwide. 1.13 to 1.16 requires the court to upload orders to the NICS system and also to notify NICS that an order has been revoked or rescinded or terminated. 1.17 to 1.18 clarifies when the court must schedule a hearing, which is 14 days after receiving a petition. 1.19 to 1.22 requires chief law enforcement officers to coordinate service of orders on tribal lands with tribal police departments. 1.23 extends the amount of time that a person has to receive notice of a hearing, a respondent, from 12 to 48 hours is the minimum amount of time that they are entitled to receive. Moving to page 2, 2.1 extends the length of time that a respondent may request an extension of the hearing to prepare for it. 2.22 through 2.4 increases the burden of proof from a preponderance of evidence standard to a clear and convincing evidence standard. 2.5, 2.6 are again clarifying that applies for both possessing and purchasing firearms. 2.17 to 2.10 reduces the maximum length of time an order may be issued from 2 years to 1 year. 2.11, again, is the burden of proof, increasing that to a clear and convincing. 2.12 through 2.16 clarifies and conforms that the extension of an order process, and that's limited to 1 year maximum extension. 2.17 is again a standard burden of proof standard from preponderance of evidence to clear and convincing. 2.18 changes the burden for receiving an emergency risk protection order from reasonable grounds to probable cause. 2.19 is again the possessing and purchasing issue, which was raised earlier. 2.20 to 2.25 requires chief law enforcement officers to request voluntary compliance with an order before they execute a search warrant to enter a respondent's home in search of weapons. 2.26 eliminates the requirement that a respondent request the return of their firearms from law enforcement. Law enforcement would be required to do so once the order is no longer in effect. And then 2.27 is a clarifying language regarding the government actors who are authorized to seek these orders.
Thank you, Mr. Diebel. Any discussion on the A5 amendment? Seeing none, all those in favor signify by saying aye. Aye. Opposed, the motion prevails. The A5 amendment is adopted. Representative Frazier, did you want to speak to your bill as amended? Again, keeping in mind the time.
Thank you, Madam Chair. Just quickly, there was discussion around that, not one thing is going to solve our issues. This is just another tool that I believe is necessary to help prevent some of the unnecessary deaths that are quite frankly preventable. So I'm looking forward to the discussion on the bill, and I can talk more during that time.
All right, great. So we do have testifiers signed up, again, like we did last time, for before and opposed, and then some public testimony. The testifiers in support of the bill, we have 15 minutes. I will note one of them had to leave. And then for those testifiers who have already testified on the previous bill, please keep in mind that we're running short of time. So if you can keep your comments short, that we would appreciate that. So the first testifier is Commissioner Jacobson. And then on deck, we have Rachel Joseph, who will be online, and then John Choi. So if you want to come on over to the testifier table, you can get ready. And then Dr. Nicholson will be last, so if you want to work your way over there as well. Welcome back, Commissioner. Please introduce yourself and begin your testimony.
Thank you, Chair Moeller, members of the Public Safety Committee. For the record, again, my name is Bob Jacobson, and I am the Commissioner of Public Safety for the state of Minnesota. I'm here today to support Representative Frazier's House File 15, which will put in place extreme risk protection orders in Minnesota. Extreme risk protection orders are another important part of the governor's public safety budget. In some instances of violence, family members, friends, or local law enforcement are able to notice warning signs that a person close to them is at significant risk of harming themselves or others. This has been found even truer with those who commit suicide, mass shootings, and school shootings. It should surprise no one in this room that suicides are the leading cause of gun-related deaths in Minnesota. While homicide statistics frequently make the headlines, it is firearm suicides that are affecting more of our family, friends, and community members, particularly in greater Minnesota. There are likely many in this room that have been impacted by the suicide of a loved one. Much like criminal background checks, this bill will not fix every issue or remove every gun from every dangerous location, but I do believe it will help. I'm glad law enforcement's in the room today, as they are an important part of the process. House File 15 would give family, friends, and law enforcement a way to intervene before something truly terrible happens. Here in Minnesota, we've experienced school shootings, mass shootings at workplaces, and barricaded suspects like was experienced last week in White Bear Lake, in which a law enforcement member was shot. As we learned in the Violence-Free Minnesota 30-year retrospective report, firearms are the most frequent weapon of choice and are used in almost half of the documented domestic violent homicides in Minnesota. This bill has the ability to reduce the number of terrible acts and victims of gun violence in Minnesota. Firearm safety and common sense gun laws will keep everyone safe in Minnesota. The governor, lieutenant governor, and I support House File 15. Thank you, Madam Chair.
Thank you, Commissioner. We're going to move next to Rachel Joseph, who is on remote. We can see you, Rachel. I can see that you've unmuted yourself as well. Welcome to the committee. Please introduce yourself and begin your testimony.
Thank you, Chair Moeller and members of the committee for having me here today. My name is Rachel Joseph, and I'm here because almost 20 years ago, my life and the lives of my family members changed forever. My aunt, Shelley Joseph Cordell, was murdered in the courthouse shooting at the Hennepin County Government Center. The shooter was a distant cousin of my grandmother's who'd been threatening and harassing my aunt for months. Shelley was a loving, funny, and compassionate human being. She had two great passions, her family and working with the elderly. When she wasn't spending time making sure her clients received the best possible care, she was busy planning the next holiday celebration, birthday party, or anniversary for her loved ones. She held our family together, and every gathering was in Shelley's home. I wish I had known then how scary things had gotten so quickly. In a little more than a year, Shelley's shooter escalated from filing frivolous lawsuits and harassing her to murder. Despite a lifetime of documentation of this person's erratic, terrifying, and dangerous behavior. My Aunt Stalker was able to show up to a Minnesota gun show, pay a private seller $60, and walk out with a .38 revolver. She then used that gun to shoot my aunt's lawyer, Rick Hendrickson, in the throat at point blank range. Then she used it to hunt and murder my aunt in a courthouse bathroom. Had Shelley been able to go before a civil court to seek an extreme risk protective order, something that HF 15 would provide for, her killer may have never gained access to that gun. HF 14 is designed to expand background checks to all gun sales, including private sellers. While it is too late to save my Aunt Shelley, states that have passed this law have seen a near 50% reduction in many types of gun violence, including gun suicide and gun trafficking. I want to be clear, Shelley's murderer chose to use a gun for a reason. No one was able or willing to help my Aunt Shelley. Not the Ramsey County courts who banned the shooter as a frivolous litigant, not the armed deputy who was present right there that day, not the security guard who ran away when he saw the gun. The presence of good guys with guns didn't make my Aunt Shelley safer. This pro-gun system, from the moment Shelley's murderer purchased the gun until the moment she pulled the trigger, taking my aunt's life, failed. And it failed completely, just as it has failed families across this state and nation countless times. In my family's case, a gun robbed Shelley's daughter, my cousin Jennifer, of a loving mother, and it erased the possibility of Shelley being a grandmother to 3 beautiful grandchildren. It deprived my father, Scott, and his brother, John, of their big sister. It stripped my grandma, Jerry, who is now 99 years old, of her only daughter. And it stole from me my aunt, a person who was foundational to my life, to all our lives. And it doesn't have to be this way. This year will mark the 20th anniversary of Shelley's death. I've been to the Capitol more times than I can count. Each time I've asked that we strengthen our gun laws, and I knew that no action would be taken, that a divided state government would ignore the wishes of the majority of its citizens for gun laws to be strengthened. Laws that would have protected my aunt, laws that would have better protected the loved ones of other survivors who have spoken here today, laws that would better protect children. Children who are now more threatened by guns than any other illness or accident that might rob them of their lives. But today is different. Today, our government is no longer divided. Today, there is a trifecta. Good. So make no mistake, today I'm not here to ask for better laws. Today, I'm here to demand them. It is long past time. This committee must pass both HF 14, HF 15, and the other gun safety laws that sit before you today. It's not a request, it's a moral imperative. Too many lives have been stolen, too much time has passed. The time to act is now. My Aunt Shelley's life, the lives of others that have been needlessly stolen, and the lives of those who survived demand your action. Thank you.
Thank you so much. Our next testifier is John Choi. Welcome to the committee, and introduce yourself and begin your testimony.
Thank you, Madam Chair and members of the committee. My name is John Choi, and I am the Ramsey County Attorney, but I'm here today on behalf of the Minnesota County Attorneys Association, an association that represents all 87 elected county attorneys across the state of Minnesota and their assistants. And we're here today to stand in strong support of the legislation that Representative Fraser has brought forward, and we thank him for his work in working with law enforcement to pass this law, which would be an important tool, I believe, not just for the government, for law enforcement, but really for our families and communities, who oftentimes, we just heard the story of what the prior testifier talked about, but we hear about this time and time again. And if we're getting involved, we're too late. But we have all of these stories of people that know that they have a loved one, they know somebody in their community is going through some sort of mental health crisis, and this is for extreme situations. and this bill has the safeguards in place to allow for, in these emergency situations, to take the gun away from the person who is a risk to themselves or to other people. I think this is one of the most important pieces of legislation that this body can do to help give tools to law enforcement and to our communities to, because we can identify these situations. Many family members are living this every day. But oftentimes they go to government and they can't get solutions or about what they can do. This allows a very clear path so that something can be done to prevent the tragedies that we see time and time again. So members, I encourage your support of this bill and to do right and give tools to our law enforcement and our communities. Thank you so much.
Thank you. Dr. Nicholson, welcome back. Please introduce yourself yet again and begin your testimony.
Yeah, thank you, Madam Chair and members. Will Nicholson, again, I'm a family physician, a hospitalist, and the president of the Minnesota Medical Association. And thank you for the heads up. I will limit my comments. Let's talk about preventing suicide. Let's go there and let's bring the facts. So we've studied this. Studies exploring a link between laws that are similar to HF 15 and reducing rates of suicide have made clear that these laws work. Indiana's suicide rate declined by 7.5% when its extreme risk protection order law took effect. Connecticut's suicide rate declined by 14% when enforcement of its law was increased. This research makes clear that these laws reduce deaths in our communities. Now, opponents to the bill will say that individuals who wish to take their own lives would simply find another way to do so. As a physician, I can tell you that is not accurate. Suicide attempts by firearms are dramatically more lethal than other means. Guns are made to kill. According to the CDC, in 2014, about 87% of firearms suicide attempts were fatal, compared to 3% of attempts by drug overdose. Suicide attempts involving firearms are 2.6 times more lethal than the second most lethal suicide method, which is suffocation. Because suicide is often an impulsive decision, removing firearms from the immediate vicinity of a potential victim can reduce death. When a person is in crisis, loved ones, law enforcement, and the people closest to them are often the first to see warning signs that he or she poses a threat. Extreme risk protective orders empower family and law enforcement to petition for an order that removes guns from a high-risk situation. On behalf of Minnesota's physicians, I strongly urge you to support this important life-saving proposal. Thank you.
Thank you for your testimony. We'll move now to those in opposition of the bill. We have Daniel Ward, Reverend Christopher again, and Rob Dorgan. If the three of you want to work your way up to the table.
Oh, man.
I did see Mr. Dorr walk out for a second here. Do we have any of those other testifiers? I think Reverend Christopher, if you want to come on up. All right. Welcome to the committee. Please introduce yourself and begin your testimony.
My name is Daniel Ward. Good morning, Madam Chair and committee members. I've testified before the committee several times before, and I, have looked at all of this, and, I know what the intent is. I know what's trying to be done. But I think it's been said before, a lot of this has a lot of unintended consequences if it's not thought through properly. I'm a service-disabled vet. I'm a father. I'm a firearms instructor. I'm certified through NRA, USCCA. I'm a range safety officer. I also am certified to train other instructors. We talk about this in some of the classes that I teach. I've also worked for Homeland Security, as well as currently I work with an executive protection firm. If you enter someone's home in an attempt to exercise an ERPO, And the due process of notifying that individual that this is gonna happen, doesn't happen. It's 3 o'clock in the morning, or at the time that person's there. They've got dogs, they've got children. Law enforcement has no responsibility for the damage they do to that person's home, devaluing their property. If there are injuries that are suffered in the process of trying to administer this, law enforcement also has the potential of getting harmed themselves. My case in point, I've had neighbors that did not like the fact that I did not want them petting my dogs. I have very large dogs. They're pedigree dogs. And there were 28 calls to service to my home. Why? Not because of a problem, but because my neighbor just did not like the fact that I told him, no, these are my dogs. They're not dogs for you to pet. He was upset. Let's say this happens where dad takes away little Johnny's Xbox. In the provision, yes, someone could be charged with a misdemeanor, but little Johnny's a minor. You're gonna charge little Johnny with a misdemeanor? He's a child, he's a juvenile, and those cases are closed. All because dad told him, no, you can't play with your Xbox. So he then reports mom and dad, says they've got guns, they're gonna do this, they're gonna do that. Law enforcement goes out, kicks in the door, and now we've got a mess of unconsequences that no one thought of here. I want you to really consider what could happen, not what you want to happen, but what could happen. Because there's always the little thing that you didn't think about that pops up. So with that in mind, really consider what could happen and think about our vets, particularly the vets that have been overseas, that have gone through stuff that people may not like them having guns and report them because of a bad situation where a romantic situation did not work out. Just think about that. Thank you.
Thank you for your testimony. Reverend Christopher, welcome back. Please introduce yourself and begin.
Well, thank you very much, Chair. Again, my name is Reverend Tim Christopher. I am part of the Minnesota Gun Owners Caucus. We just, right here in the Rotunda, celebrated Amir Locke's day that he was murdered, where there was a raid, a no-knock raid that a Minneapolis mayor lied about. This bill is one that scares me when it comes to the Black community. Somewhere down the line, that bill could be used as a no-knock raid on the Black community. I think Cedric knows exactly what I'm talking about when we find people bursting into Black people's house. Somebody can say something or tell something. This bill is the one that really, really, like I said, scares me, and I feel that will hurt us more than it'll help us. Because Black people don't tell. We don't snitch, right? We don't snitch. Like they say, snitches get stitches in our community. So nobody's gonna tell on somebody who has a gun, but I believe it could be used by law enforcement to go burst into somebody's house unannounced, and then we have another young man like Amir Locke. You don't see a lot of Black people up here because we're afraid to tell you that we got guns. See, when you all let Fernando Castile get murdered and nobody said nothing, and that man walked away scot-free, we don't show you our firearms. I don't show you what I got on my hip. I fight for it. I talk to my people about it. I ask them to come in to be a part of this. But see, in a lot of people's minds and thoughts is the only time you see Black people are the thugs that have the gun. John Choi is probably part of the problem.
Sir,
Because he will not prosecute the gun owners, the gun.
Sir,
I know what you're about to
talking
say.
about the bill.
I know that. He's part of the bill. We've got to start prosecuting these people with these guns. They cannot walk out the back door and go commit a gun again. There was a guy who shot a pregnant woman in the Amazon parking lot. Y'all remember that? Anybody remember that? He shouldn't have been able to have a firearm. He shouldn't even been probably out of jail. If y'all gonna get serious about this stuff, let's get serious. And let's save some black lives also, because black lives do matter. And I'm done.
Thank you. Final testifier is Rob Dorr. Welcome to the committee. Please introduce yourself and begin your testimony.
Members of the committee, Madam Chair, Rob Dorr, I'm the Vice President of the Minnesota Gun Owners Caucus. I'm going to be zeroing in mostly on the emergency order portion of this, because I think those have the most clear violations of due process and the largest good intent, but lack of ability to meet the expected needs. I want to start off by saying suicides, we all know nationally it's about 2/3 of suicides. Here in Minnesota, 80% of our firearm deaths are suicides. It was asserted earlier that this bill would help reduce suicides, and Connecticut or Indiana was mentioned. I have some information which I'll leave available for you. I didn't include it earlier because I didn't think I would need it, but Connecticut, when they passed their red flag law in 1999, their suicide rate was 7.9. Per 100,000. In the last 5 years, it's been averaging above 10. For Indiana, when they passed it in 2005, it was about 11.8 per 100,000, and they've been steadily above 14, all the way up to 16.4 for the last 4 years. So you can see it's trending far up, and I have this for you if you'd like. In fact, every single state that has passed red flag laws, and I have the data on that here, has not seen a reduction in suicide rates as a result of passing those bills. I only say that because I'm an EMT. I know there's EMTs who are on this committee. We know that and law enforcement members certainly know that we have what's in law is a 72-hour hold. If an individual is presenting with a mental crisis and they're in danger of harming themselves or others, they can be placed on a 72-hour hold for medical evaluation. There's also for domestic abuse situations. If an officer arrives at a scene and believes that domestic abuse has happened in the last 72 hours or is imminent, there's a shall arrest provision in statute. They can't issue a summons. It is a shall arrest situation. Both of those things actually address the individual in crisis, the person who is in crisis. What the red flag law does is it operates, these emergency provisions, operates under the presumption that the situation is so urgent, so emergent, we can't afford to bring this person into court, but we get a secret order, we go knock on their door, take their firearms, and then now that the firearms are gone, the situation's fine. That is an entirely false premise. If the situation is so urgent that we can't afford the person the due process provided in an adversarial court hearing, then it certainly is urgent enough to address the individual in crisis through the mechanisms in current law. I have great concerns. I'll direct you to line 10.10 of the delete all amendment. The standard to get an emergency order is probable cause. That is way too low. Probable cause is just one step above reasonable suspicion. It is facts supported by some evidence. And you know what? It's really easy for a judge to conclude facts when they're only getting one side of the story, when there's not somebody there to offer a counter narrative. It's not, a clear and convincing evidence is what's used earlier in the bill for a standing order, but the emergency order that goes in, takes somebody's firearms only on a preponderance of the evidence, that's far too low. I just conclude by saying we all share a common goal in wanting to make sure that guns stay out of the hands of the people who pose a danger to themselves or pose a danger to others, but let's actually address the individuals in crisis, not operate under a false premise that it's the firearms that are the danger in that situation. We can't go into somebody's house, remove the firearms, leave all the knives in the kitchen, a medicine cabinet full of pills, rope in the shed, Ford F-150 pickup in the garage, and think that that person is now safe and not a danger to themselves or others. Thank you.
Thank you for your testimony. We'll move now to public testifiers. And if these three folks can come on down, we've got Joan Peterson, Fred Garacco, and Sue Abderholden. And actually, Brian, gosh, if you want to come forward too, you can. Our final public testifier, it will be remote. Joan Peterson, you can begin your testimony. Please introduce yourself and begin.
Good morning. I'm Joan Peterson from the Cloquet, Duluth area. I'm a leader in the Northland Brady chapter, also working with Protect Minnesota. When I testified in front of this body in 2003, I was shaking because I was nervous. It's now 2023, and I'm shaking because after 20 years of advocacy in the name of my sister Barbara, who was murdered in 1992 by her estranged husband, we are on the cusp of doing something to prevent thousands of people from being shot. I wear her photo near my heart. In 1992, the year my sister was killed, there were 37,776 victims of gun violence. Last year, an all-time high of 44,299 lives were lost to bullets. If this many people died of any other cause, we would declare it a national emergency. The fact that we have not is an American tragedy. According to Brady, 99% of risk orders resulted in the removal of at least one gun, and 44% of orders led to the respondent receiving psychiatric treatment they would not have otherwise received. A recent Joyce Foundation poll found that 86% of Minnesota voters support extreme risk protection orders, and 78% of gun owners agreed. Bills like HF 15 are popular. Yes, life is difficult for victims and survivors of gun violence. It was difficult to get the phone call about my sister. It was difficult to attend her funeral. Please listen to the voices of the majority of Minnesotans who have repeatedly told you that they expect legislators to pass measures that will save lives. Thank you.
Thank you for your testimony, and I'm sorry about the disruption during it. Our next testifier is Fred Gurico. I don't know how to pronounce your name. Gershio. Welcome to the committee. Please introduce yourself and begin your testimony.
Madam Chair, I'm Fred. Would
yep.
you want to just remind everybody, turn them down?
Yeah, that's a good point. Like at the movie theater, everybody check right now. I'm nervous that my ringer might be on too. Make sure your phones are off. Thank you. Now you can introduce.
I looked before, I couldn't figure out how to shut off the ringer.
It's okay. I think we've all been in that situation before. Please introduce yourself and begin your testimony.
I'm Fred Gercio. I live in Burnsville, Minnesota. I've been advocating for the Second Amendment for over 40 years, older than some of these people in this room. And some of my documents that I've used all over the country have had 50 million views, according to the video clicks. So not only did they read the document, they went through and probably the 25 videos in there, they looked at them. YouTube and the government rewarded us by removing millions of clicks, 5, 10, 15 million at a time. And not only that, but one of the primary documents is 2011 FBI Crime Table 1. Google actually removed it from search for about 7 years until I complained to the U.S. Attorney General. It was gone. You couldn't find it. It wouldn't show up until page 6. That table says 2011 FBI Crime Table 1. There are 10 violent categories of crime. It was down every year, every category for 20 years. At the end of that 20-year period, you would need to increase crime in all categories 2 to 3-fold to reach the 1993 levels. Crime reduction was in the states that passed castle law, conceal and carry, and things like that. So their violent crime dropped 60, 70, 80% in 2 or 3 years. There are liberal states that have red flag laws, 100% background checks, even ammo, don't have those reductions. They're going up 10, 15 to 65% per year, depending upon the state or the city that you look at. So, and then we talked about the background checks. You know, they only convict 3 bad guys per year. 2016, 17, 18, and 2011. And even the GOA confirmed this. 3 bad guys per year. They took $2 billion per year in background checks from the American citizens and convict 3 bad guys. Right now, if we do it on everything.
Please wrap up your testimony, sir. Final sentence.
Well, actually, I was supposed to be on both hearings, and they told me that I could only speak on one now.
We told the public testifiers that they'd be able to testify to one. So final sentence, please.
Yeah. So if we get this on all the checks and things like that, that's $22 billion a year, and they're not doing anything with it. These are constitutional, God-given rights, the highest law in the land, and we're throwing it around like it's tish-tosh. It's 100% party lines. And I think when the Supreme Court is done with this and they're about to hear some of this stuff, this will almost be considered treason in my eyes. Thank you very much.
Thank you. Welcome to the committee, Ms. Abderholden. Please introduce yourself and begin your testimony.
Thank you, Madam Chair. Members, Sue Abderholden, Executive Director of NAMI Minnesota, the National Alliance on Mental Illness, and co-chair of the Mental Health Legislative Network, a coalition of over 40 mental health organizations. In 2020, 733 people died by suicide in Minnesota. Men made up 80% of those suicides. In 2020, there were 513 firearm-related deaths, and about 70% were suicides. We want to prevent these deaths, and one strategy in suicide prevention is called means restriction. This is when we restrict access to lethal means to prevent someone from taking their own life. Time is key to preventing suicide, to help them see the crisis won't last, and to connect them with someone who can help, which is why limiting access to lethal means is so important. NAMI and the MHLN support this bill, but would like to see some changes. We're not talking about harm to self, a term used in the Commitment Act, or bodily harm, a term used in criminal statutes. We are talking about people who may be deeply depressed, who have lost hope, and are at risk of suicide, of taking their own life. Use the term at risk of suicide instead, and please do not connect suicide with violence. Suicide is a health issue, and thus those orders should be private and not public. I have sent Representative Frazier our suggested wording changes, and I'd also like to ask that you look at House File 2534, introduced during the 2012 legislative session. I've been around a while. A bill we developed to actually create a voluntary registry so people could place themselves on the registry to prevent suicide. I know people have mentioned the 72-hour hold under the Commitment Act, and I just want to say that that won't work because right now we have a lot of trouble with police actually taking the word of our mental health professionals on the crisis teams and even actually responding to some suicides when a gun is involved and no one else is in the house. Thank you.
Thank you for your testimony. Next, we have Brian Gosh, I'm not sure, but you can introduce yourself and I'll know. Welcome to the committee. Begin your testimony.
Thank you, Madam Chair, members of the House Public Safety Committee. My name is Brian Gosh. I'm a lawyer and registered lobbyist with the National Rifle Association of America. I want to commend Representatives Hudson, Grossell, and Novotny. I thought they summed it up very well. And we are on record opposing all four bills before the committee today. These bills will not do anything to reduce gun violence in Minnesota, and those representatives nailed it when they said that. It's only going to put obstacles and burdens in the path of law-abiding citizens to own, use, possess, and enjoy firearms. California has the strongest red flag language out there. They just had a mass shooting. They had a school shooting not that long before that. It's just, these aren't going to work. You're targeting the wrong area. Particularly House File 15 is bad. It allows for the confiscation of a respondent's firearms upon very little notice and before they can be heard by a judge. The bill allows for low standards of proof for the seizure of firearms and can be based on uncorroborated hearsay evidence. In addition, House File 15 only confiscates firearms and not other dangerous items in the individual's household that can inflict harm if they in fact truly want to inflict harm on themselves or others. Moreover, there's nothing else, or there's nothing in the bill that would speaks to the respondent getting mental health treatment, you know, like you have in the civil commitment process under existing statutes now, and not even evaluated by a mental health professional. If you truly believe this person's a danger to themselves or others, that should be part of this, right? Once the firearms are confiscated, there's no clear path to the return of them or to innocent owners' firearms being returned. And I guess I'm out of time, so with that, thank you for your time, Madam Chair, members of the committee.
Thank you for your testimony. Our final public testifier is Kelly E.W. Roscom, who is online. We can see you, and I can tell that you've unmuted. So welcome to the committee. Please introduce yourself and begin your testimony.
Good morning, Chair Mueller and members of the committee. My name is Kelly Roscom. I'm the Director of Law and Policy at the Johns Hopkins University Center for Gun Violence Solutions. And in that capacity, I have worked on extreme risk protection order laws in 17 states and the District of Columbia. I was also born and raised in Minnesota and have a deep commitment and love of this state. I'm here to testify on behalf of HF 15, the Extreme Risk Protection Order bill that is currently law in 19 states and the District of Columbia. These laws are narrowly tailored, respect constitutional rights, and are effective at reducing gun violence. They're modeled significantly after domestic violence restraining orders and incorporate all of the due process protections contained therein. a petitioner, a law enforcement, or family or household member has to request an order from a judicial officer. They bear the burden of proving that that person represents a significant risk of harm to themselves or to others. Evidence also suggests that ERPOs are a valuable tool to prevent gun violence, particularly suicide. One study of Connecticut's law between 1999 and 2013 determined that for every 10 to 20 orders issued, at least one suicide was prevented. Now, that may sound very small, but one person means an awful lot to a lot of people in Minnesota and elsewhere. Another study of Indiana's ERPO law determined that in nearly 70% of cases, suicidal ideation was cited as the reason for the issuance of that order, and for every 10 orders issued, one suicide was prevented.
And you maybe, sorry to interrupt you, but you maybe didn't hear that the timer went off, so if you could just wrap it up with a sentence, that would be great. Thank you.
Absolutely. Thank you so much. These laws are effective, they're constitutional, and they can be used to save lives. I strongly urge you to support the bill. Thank you so much.
Thank you for your testimony, and thank you to all the testifiers on this bill. We'll move now to member discussion, and we do have an A2 amendment. Who will be offering the A2 amendment? Representative Grossel to the A2.
Thank you, Madam Chair. And A2 is very straightforward. After an extreme risk protection order is issued and someone has to surrender their firearms to law enforcement, this amendment simply makes the law enforcement agency financially responsible for any damages to those firearms while they are being stored. And if you look at the handout, you can see a lot of times if weapons are seized, they're put into, look at the picture, you can see where they're put into shopping carts, barrels, et cetera, shelves. And I can assure you that Representative Becker-Finn, myself, and anybody else who is a hunter, you spend some money on these rifles and shotguns and such, then you don't want them damaged. So if this protection order is executed, then at least to make sure that if there is something damaged, that it is accounted for. I'd ask for a yes vote, please.
All right, great. Representative Frazier to the A2.
Thank you, Madam Chair. Representative Grosso, I appreciate that concern. In fact, that's a lot of the conversations I had with law enforcement when we talked about this bill, is how we will appropriately store these weapons to ensure that they are returned in the manner and in the order in which they were transferred in the first place. Our laws already allow for municipal tort liability. So there's always, the law already covers this. And we will be providing resources for storage so they're properly stored and these weapons are not damaged and they can be returned back to an individual. So I would request a no vote on this amendment.
Discussion to the A2. Closing comments, Representative Grosso.
Just very short, Madam Chair. We've got a lot of laws that we already have on the books, and we're modifying those and not using those currently either. Representative Frazier, I would ask for a yes vote.
All right, those in favor of the A2 signify by saying aye.
Aye.
Opposed? No. The A2 amendment is not adopted. The next amendment is the A3. Who is offering the A3? Representative Whitty to the A3.
Page 13, line 25, delete the word gross. After a person must surrender their firearms, the bill says law enforcement is only liable for damage as a result of gross negligence, which an extreme departure from ordinary standard of case. This amendment makes the standard negligence. Obviously, we just saw a shopping cart full of guns in an evidence room. But a definition of gross negligence is heightened degree of negligence representing an extreme departure from the ordinary standard of care.
All right, Representative Frazier to the A3.
Thank you, Madam Chair. Representative Whitty, also I appreciate your concern for how law enforcement will handle these items once they're in their possession. We had conversation with law enforcement. We put this in there. We want to ensure them that they can do this job without having to be concerned about any extra liability. I'm going to say in my conversations with them, they are very concerned about making sure that they don't damage any of these items that they have to hold for short period of time. I'm going to ask for a no vote on this because I don't want to put them in a situation where it's going to cause issues for them to execute these transfers any more than, it's going to be some emotional things here, but I don't want to create any more than we have to create.
All right, further discussion on this amendment, and Representative Whitty, closing comments. We're getting note from the media that you couldn't pick you up.
Sorry about that.
Yeah, that's all right. All
I
right,
gotta put the
closing
mic in front of me next time. The only thing I would say is I think this is gonna be one of those, on account of consequences, and it is gonna hurt law enforcement because a gun is gonna get damaged and it's accidental or however, and it's, I think it's just one that would have protected law enforcement on this one, but, I would vote yes. Thank you.
All those in favor of the A3 amendment signify by saying aye.
Aye.
Opposed? No. The motion does not prevail. The A3 amendment is not adopted. The next amendment is A4. Who is the author of the A4? Representative Hudson to the A4.
Thank you, Madam Chair. The A4 amendment would delete the section of the bill that establishes a emergency issuance of an extreme risk protection order. And the case for this amendment was made artfully by Rob Dorr. And again, just to summarize, if the circumstances exist such that we're going to argue that it's really, really super duper important that we get in there and take somebody's guns because they're a danger to themselves or others, they probably need services above and beyond just having their guns confiscated and then left alone with everything else in their house and everybody else around them who they know. And so if we want to address mental health issues, we already have a 72-hour hold established in Chapter 253B. That's a mechanism that can be utilized, and we can pursue through other legislation services that will help people in crisis, as opposed to just coming in, taking their guns, and leaving the situation as if we've solved a problem.
Thank you. Representative Frazier to this amendment.
Thank you, Madam Chair. Representative Hudson, I will again say that I don't think that these laws are panacea. I don't think that these laws solve every problem. If someone is in need of mental health services or they're going through a mental health crisis, I think we should find ways to provide them with that help. But I also don't believe that we should leave the one thing that can absolutely take them away from us to where we cannot help them in place while they're going through that mental health crisis. I would have to say I've listened to the testifiers, and I've heard mental health professionals testify. I've heard gun enthusiasts testify. I'm going to have to side with the mental health specialist in this situation. I might say a vote no on this one.
Further discussion to the A4. Oh, Representative Namani.
Thank you, Chair Moeller. Several years ago, when they started doing the submitting of your firearms and associated with domestic abuse orders or order for protection, I was actually running the evidence room at our sheriff's office where I was working at the time, and having conversations with some of these people that were turning in their guns. Many of them were flustered, but at least they had had their day in court and been able to express or counteract the claims that have been made against them. I think the ambush part of this with the ex parte hearing is what gives me the biggest concern and what I feel will be putting law enforcement at the biggest risk in dealing with these people in the future. I could go on, but we're limited for time, and I just think that it's the ex parte part and the denial of the constitutional rights that's the biggest problem with this right now. Thank you.
Representative Pinto.
Thank you, Madam Chair. I'll just note briefly that we have ex parte orders for protection, harassment restraining orders. This is not a new concept in our laws at all. We've had these for a long time. And so this is simply following a parallel process with that. Thank you, Madam Chair.
Further discussion. Representative Frazier. I heard a voice. I couldn't tell where it was coming from. Go ahead.
It was me. Thank you, Madam Chair. No, and I actually had this conversation with law enforcement, and the question I always raise is, how is this dissimilar from what Representative Pinto just described? And their response was, it is not.
All right, closing comments to this amendment, Representative Hudson?
Thank you, Madam Chair. Well, I would most certainly disagree with that. I mean, there's a very clear difference. I don't have a constitutional right to come within so many feet of anybody I want. So a protection order, that's something that if you're able to demonstrate with the preponderance of evidence that somebody is presenting an imminent threat or an ongoing harassing situation to someone, an ex parte order saying this person shouldn't be around that person may indeed be appropriate. But what we're talking about here is literally a constitutional right. It's the second thing on the list of things that our founders were coming up with when they were thinking, gee, how could this go wrong? Number 2 was the right to keep and bear arms. So if we're going to curtail it, if we're going to take that right away from someone, they should at least have the right to hear their accuser and make their case. And if we're going to judge that the circumstances are such that it constitutes such an emergency that we can't even do that, then I would say those circumstances add up to justification for placing them on a 72-hour hold. So please vote for this amendment.
It's me again.
Representative, well, hang on a second here. I heard Representative Novotny. What did you say? Okay, can you just move the mic so it picks up?
Requesting a roll call, Chair.
Thank you. Representative Novotny requests a roll call. Representative Frazier?
Yeah, just quickly, I was referring to the similarities between the current protection orders that we have in place now that law enforcement have to execute. But I like history. So I will say that this, the Second Amendment was not actually the number 2 thing that the framers, when they were having the conversation around what should be the number 2 amendment, it was not that. There were several other things, and there are some great history around why the Second Amendment actually does exist, based on some Southern landowners, but thank you for that.
All right, we're moving to the A4 amendment. All those in favor, sorry, roll call has been requested. Sorry. All right, the clerk will take the roll on the A4 amendment.
Chair Moeller?
No.
Moeller, no. Vice Chair Feist?
No.
Feist, no. Representative Novotny?
Novotny, aye.
Novotny, yes. Representative Becker-Finn?
No.
Becker-Finn, no. Representative Curran?
No.
Curran, no. Representative Ingen?
Yes.
Ingen, yes. Representative Fraser?
No.
Fraser, no. Representative Grussel?
Yes.
Grussel, yes. Representative Hollins?
No.
Hollins, no. Representative Hudson?
Yes.
Hudson, yes. Representative Hewitt?
No.
Hewitt, no. Representative Mueller?
Mueller votes yes.
Mueller, yes. Representative Pinto?
No.
Pinto, no. Representative Tapke?
No.
Tapke, no. Representative Whitty?
Yes.
Whitty, yes. There being 6 ayes and 9 nays, that concludes the roll call vote.
There being 6 ayes and 9 nays, the motion does not prevail. The A4 amendment is not adopted. There are no other amendments filed, and we will move to a discussion of the bill. Representative Whitty.
Representative Frazier, would you take a question?
Yes.
Under 2.22, a peace officer who's informally admitted to a treatment facility pursuant would have their weapon taken away. We do talk about PTSD, if I'm looking at this right. Would PTSD, if they go out on PTSD, would that be a part of it?
Representative Whitty, I think.
Am I on the wrong one?
Well, I think you're referring to what currently is in statute. That doesn't change. So line
Okay.
2.22 to 2.26, paragraph 6 is what's currently in statute.
Okay, and then, but I guess my question would be, would PTSD be a part of this?
Representative Frazier.
Thank you, Chair Moeller. Representative Whitty, you know, I think that determination would be up to the presiding adjudicator who's making that decision based on the facts that are provided and evidence that's provided.
And I apologize for the confusion.
Representative Whitty.
I guess the other part for me that I would ask if you would be open to is if there's ever, there'd be a crime for false claims. If someone would claim like a domestic partner and they would put you on this list and law enforcement would be coming and it was found to be false, or we have swatting crimes, someone in the community does that and now the police are coming to your house just to kind of enhance this area, so there would be a crime for the false claims.
Representative Frazier.
Representative Moeller, I believe we do have that addressed because that was one of the main issues that I talked with law enforcement. They were concerned about angry exes.
And I believe, Representative Frazier, I'm seeing, so this is the unamended version, but line 13.6 to 13.9. I believe deals with the false claims.
Thank you, Madam Chair, that is correct. Representative, we do address that.
Thank you.
Further discussion, Representative Becker-Finn.
Thank you, Chair Mueller, and I wanted to share a real-world example of when if this had been law, how we could have prevented a death and prevented an injury to a police officer. So last year, actually in my neighborhood, could hear the gunshots in my own home, had to bring my children to the basement. Actually texting my neighbors who I knew were not gun owners to let them know that was not fireworks and they should go to their basements. We had someone who had been struggling with mental illness, had been an adult, in and out of civil commitment, but at the time did not meet the standard to be civilly committed. There had been at least 15 calls to law enforcement about this person. It was known that this person was at high risk to do something unsafe. And what he did is he went to his adult parents' house and went and got a rifle from his parents' house and fired over 200 rounds into my neighborhood. And those bullets were fired into multiple neighbors' homes, garages, vehicles, and one of those bullets actually was lodged in the neck of one of our police officers who was one of the first to respond. It was extremely traumatizing and scary for our entire neighborhood, our entire community, for all of the first responders who showed up. The officer had to be dragged to safety while still taking fire by our firefighters and other officers on scene. And eventually this, after a standoff and many bullets fired, continuing to be fired into our neighborhood, this person was eventually shot and later died of his injuries, shot by police. You know, it was found that they were completely within their rights to do that, given the entire situation. And this was a person where the parents knew that he might come get a gun. They, so, you know, maybe safe storage would have also stopped this situation, but had this tool been available, I have no doubt that our law enforcement, either where this person lived or in the jurisdiction where his parents lived, could have filed one of these orders and could have gone in and made sure that he did not have firearms in his home. And I know there's been some discussion, and I think it's valid to talk about keeping officers safe when they're executing these orders, but it would be no different than when they're executing any other search warrant or order. And in this case, this person was known to go to church every week. Officers could have executed this and gone in and taken and made sure he didn't have firearms available to him at that time. And so I wanted to share that because I do think this is a tool that we don't have and would have prevented that officer getting shot in the neck, and would have prevented, hopefully, this man from losing his life as well. He was obviously someone in crisis, and I will end this with Officer Duxbury has underwent surgery and is hospitalized, but he is okay, and he has you know, we're very lucky that he's still with us and able to serve our community, but just a very real world, real example of when this bill could have, prevented a tragedy. So, thank you.
Thank you. Representative Hudson.
Thank you, Madam Chair. It's just fascinating the way this process is timed out. Last night, we considered a bill by the same author, passed off the floor, and the argument that we heard was that it's deeply important to restore civil rights to convicted felons who have not completed their sentence. Because, rationale, voting is a sacred right. It's so sacred. Why, though? Why is voting a sacred right? Why is any right a sacred right? Our most sacred right is our right to life, because our life is from where our rights are derived. We get to protect ourselves because we have the right to live. That's what the Second Amendment is about. It's a reason why it has such a prominent place in our Bill of Rights. The idea, especially after the refusal by the majority to accept my amendment to this, the idea that the solution to a crisis is to deprive someone of that right exclusively, the right to keep and bear arms, without due process, and deprive them of no other right. So we're not gonna take them into custody, we're not gonna provide them with services, we're not gonna have a trial to determine whether or not they're guilty of a crime. We're just gonna take their guns while they're at church, apparently. They come home, find out their guns are gone. All their problems are still there, but their guns are gone. And consider that we've done something meaningful and important. This bill misses the mark. And again, I think the problem here is a problem of focus. We're focusing on the utensil, the object, rather than focusing on the people and the person, perpetrators. And so I most certainly plan to vote against this. And again, I can't appreciate the irony enough of, after spending hours on the House floor last night arguing that we need to restore civil rights to people who have violated the rights of others, that we're now arguing to take rights away from people within less than 24 hours. I'll request a roll call vote.
Thank you. Representative Hewitt.
Real quickly, Madam Chair, I know you're in a hurry, and Representative Hudson, welcome to the Minnesota House. I want to go back to the 72-hour hold that keeps coming up in these cases. I've been involved in a lot of these, and it's not as easy said than done. If a medic or an EMT have to go and take somebody and restrain them, there is a process. There is a lot of involvement in that. I'm sure Representative Whitty has been involved in some of these. We have to get the police involved. They have to sign a hold order. We can't just take somebody. Your rights are very protected in this. This scenario doesn't play out in what we're talking about here. When we get a call to a house that basically there is somebody in crisis and we determine they don't want to go with us because we need to bring them to the hospital. We need a physician to sign that 72-hour hold. But it's all done in a processed way. It's not something you can just slap on somebody at their house. And it's very, very careful. And so this isn't, you're talking about apples and bananas when you're talking about these holds versus what we're talking about here today. So it's not really a tool that can be used right now. These are used when an individual is in acute crisis and they need medical attention now. Thank you.
Thank you. Representative Ingen.
Thank you, Madam Chair. Will Representative Frazier yield for a couple of questions?
Yeah, and we don't have to do that.
Okay,
That's for the
that's right,
floor.
that's
Sorry.
right. Thank you
Yeah, I
for
know.
that.
We've been on the floor
All
a
right,
lot lately,
yes.
so it's right.
So Representative Frazier, I'm actually looking at page 8, lines 8.5 through 8.9. This talks about what evidence would be appropriate or applicable in determining whether or not someone should have their firearms taken from them, correct?
Well, and just for clarification, Representative Ingen, are you
That's
referring
relieved by
to the
court.
DE2 or the bill before?
The bill.
Just the House File 15?
Yep.
And say again what line?
8.5 through 8.9.
I'm not seeing an 8.5 to 8 point.
That's
here.
relief by the court under the unengrossed. Is it in the DE?
Mr. Debo, can you help?
Looking at the actual.
Yeah, we're going to refer to Jeff
we'll
Diebel
get-
here
we'll
and see
get
if he.
Madam Chair and members, I believe he's on track to talk about the evidence to be considered by the court. Which is where? Which is on page 8 of the bill.
Okay, my apologies.
No,
Go ahead.
It's okay. So would that be correct, Representative Frazier?
Is it 8.5? Maybe I don't have the right document in front of me.
Yeah.
8.5 through 8.9.
All right, thank you. That is correct.
Representative Engen.
Thank you. Thank you, Chair. So I'm looking at whether or not somebody at the age of 18 could be not even convicted, but simply arrested for a violent misdemeanor offense, which would include 18-year-olds at a fight, a simple fight. And that would be applicable and appropriate evidence on whether or not their firearm could be taken at the age of, say, 45. Would that constitute clear and convincing evidence that the respondent poses a significant danger of bodily harm to self or others for possessing a firearm?
Representative Frazier.
Thank you, Madam Chair. Representative Engen, thank you. I think the court, again, adjudicating officer would have to weigh the evidence. That's the point of having those hearings. So the adjudicating officer would have to weigh the evidence, and I would imagine they would look at the distance and time between those particular events, and they would rule accordingly. I can't make the prediction on how they would look at that because it's a hypothetical, but that's what they would have to do.
Representative Engen.
Thank you, Madam Chair. So one more question here. So I appreciate that. I think that on page 8, we do want to have some definitions of what constitutes appropriate evidence for demonstrating that somebody should not have firearms. But if we go down to 8.26 and 8.27, it says other evidence that bears on whether or not, or whether the respondent poses a danger to the respondent's self or others. The subjectivity of that language, to me, indicates that the all above evidence that could be presented in demonstrating whether or not somebody shouldn't have a firearm, I mean, that's all just language on paper because other evidence could mean anything. And really, it's up to the will of the court whether or not they want to take that and utilize it to demonstrate why somebody shouldn't have their firearm. The subjectivity and ambiguity of that language is really, really concerning to me, and it could potentially neglect somebody of their rights. So for that reason, I'm no on this, but I thank Representative Becker-Finn for saying earlier that they are open, you guys are all open to changing a bill. Is that something that you'd entertain changing?
We actually may get you to the yes stand, I'm hoping, because when the mental health professional testified, that is the language that she has provided me to address some of this, so I'm looking forward to you.
Thank you.
Yeah, and thank you. And I'll just note too, with the amendment that we adopted on line 8.5, the standard actually changed from a preponderance to a clear and convincing standard, clear and convincing evidence. That is a court standard. It's commonly used in different areas of law. Courts understand what the clear and convincing standard is. And so I'll just note that was changed with the amendment. Representative Frazier.
No, that's true. I didn't know, he didn't specifically say that, so I didn't raise it, but thank you, Madam Chair.
All right, next up, we have Representative Pinto.
Thanks, Madam Chair, and actually, this is good, it kind of connects with Representative Engen's questions. So, yeah, Representative Engen, I mean, the standard here after it's amended is that it's a significant, the court has to find the respondent poses a significant danger of harm to self or others, and has to do so by clear and convincing evidence. This list is a list of ideas, of things to consider. If you got a 45-year-old respondent and a 15-year, and a charge when the person was 18 and that's all they have, then I don't know if you're the judge, does that seem clear and convincing? The person right now poses a significant danger of bodily harm? I would not think so, right? And in fact, that can be challenged, but there's a series of these are examples, right, of pieces to consider. But ultimately, the test is, does the person pose a significant danger of harm to self or others, and is that demonstrated by clear and convincing evidence, quite a high standard. And I just, again, comparing to other petitions we have, orders for protection, harassment restraining orders, similarly, there's a standard that's set, there's information to look at, in some cases they're ex parte, and I'll point out, those orders are in fact challenging a constitutional right. The First Amendment provides a right of association. So in fact, you do have the right to be near somebody else. That's actually a constitutional right under the First Amendment. And the order says, no, you don't have that because the court has determined that in that case, we're going to limit that right. So in fact, this is a First Amendment situation and other court orders, and this is just parallel here. Thank you, Madam Chair.
Thanks. We're going to have one more, Representative Grosso, then Representative Frazier, closing comments. We'll move to a vote. We are obviously over time. Our time left is limited with media, but we do have testifiers who are here on the last bill, so we want to make sure we get to them as well. Representative Grosso.
Thank you, Madam Chair. Brevity is our friend today at the end here, so I appreciate it. And thank you, Representative Becker-Finn, for bringing up two examples, bringing up that example. And I'm glad that officer survived, but that was an example of that these bills would not have stopped that. These bills would not have stopped that. Either one of them, either the safe storage or the red flag would not have stopped that incident. So thank you for giving that example. You just, you helped us there. And Representative Hewitt, thank you for bringing up due process. Thank you for bringing up the process of a 72-hour hold where a person is assessed. And then if they found to be, go back in the community, they let them go. Red flag, the due process is removed. They don't get that luxury. So thank you, Madam Chair.
All right, closing comments, Representative
Thank you,
Frazier.
Madam Chair. I wish we had one bill that would solve all the ills in our society. Folks testified, we do have violence in our society. Gun violence is a big issue in our society. Of some of the more developed countries, we have one of the biggest issues with gun violence in our society. These bills are providing more tools to help address some of that gun violence and bring down some of those incidences. We'll have further conversation with them. We may amend with more conversation with our colleagues on the other side, and I'm looking forward to those conversations, but please vote to continue the conversation.
Thank you. Representative Frazier renews the motion that House File 15 as amended be re-referred to the Committee on Judiciary, Finance, and Civil Law. The clerk will take the roll.
Chair Moeller.
Aye.
Vice Chair Feist.
Aye.
Feist, yes. Representative Novotny.
No.
Novotny, no. Representative Becker-Finn.
Aye.
Becker-Finn, yes. Representative Curran.
Aye.
Curran, yes. Representative Ingen.
No.
Ingen, no. Representative Frazier.
Aye.
Frazier, yes. Representative Grosso.
Nope.
Grosso, no. Representative Hollins.
Aye.
Hollins, yes. Representative Hudson.
No.
Hudson, no. Representative Hewitt.
Aye.
Hewitt, yes. Representative Mueller.
Mueller votes no.
Mueller, no. Representative Pinto.
Aye.
Pinto, yes. Representative Tabke.
Aye.
Tabke, yes. Representative Whitty.
No.
Whitty, no. There being 9 ayes and 6 nays, that concludes the roll call vote.
There being 9 ayes and 6 nays, the motion prevails.